You think you're in control. You think your lease agreement is bulletproof. A single eviction in California will shatter that illusion, draining your bank account and your sanity. We're talking 45 to 90 days of legal limbo and a financial hit between $5,000 and $15,000. That's not a hypothetical. That's a common reality for landlords who don't understand the game. Most of these financial and emotional hemorrhages are easily preventable. Before you even think about filing an unlawful detainer, you must understand California's stringent notice requirements. This is where most landlords trip at the starting line, invalidating their entire case before it even begins. Your first step is almost always a notice to pay rent or quit, CCP Section 1161-2, or a notice to perform covenants or quit, CCP Section 1161-3. For non-payment of rent, it's typically a 3-day notice. For lease violations, it's also a 3-day notice. These notices must be meticulously drafted and properly served. Any error, a wrong date, an incorrect amount, improper service, and a judge will throw out your case, forcing you to restart the entire process and losing you another 30 to 45 days minimum. Consider this: if you serve an improperly formatted 3-day notice, and it takes you 2 weeks to realize your mistake and serve a correct one, you've just lost 2 weeks of potential rent. At a $2,500 monthly rent, that's $1,250 down the drain before you've even filed a lawsuit. The law demands precision. You must also consider rent control ordinances. Many California jurisdictions, especially under AB 1482, require a just cause for termination and longer notice periods, often 30 or 60 days, even for non-payment if the tenancy is over a year. Failing to comply with these local rules is an instant dismissal. Now here's where it gets interesting. Many landlords overlook the practical benefit of a cash-for-keys offer before serving any formal notice. Offering a tenant $1,000 to $3,000 to vacate quickly and voluntarily, even if they owe rent, can be substantially cheaper than a contested eviction. A typical eviction involving an attorney will cost you $3,000 to $7,000 in legal fees alone, not including lost rent. If the tenant fights it, those fees can easily skyrocket to $15,000. So, paying $2,000 to avoid a $7,000 legal bill and 2 months of lost rent is not generosity, it's smart business. Once your notice period expires and the tenant has not complied, you file an unlawful detainer lawsuit, UD. This is the formal court process to regain possession of your property. You file the summons and complaint with the Superior Court. The tenant then has 5 calendar days to respond after being served. If they don't respond, you can request a default judgment, which can significantly shorten the timeline. But wait, there's a catch. Many tenants will respond, often with boilerplate legal defenses, whether valid or not, specifically to delay the process. The filing fees alone for an unlawful detainer are hundreds of dollars. Then you have service of process fees, which can range from $75 to $200 per tenant. If the tenant requests a jury trial, which they have a right to do, your legal costs will explode. A jury trial for an unlawful detainer case can easily add $5,000 to $10,000 to your attorney fees due to the increased preparation and court time. This is why attorneys often advise against jury trials unless absolutely necessary. Your primary goal is to regain possession, not to win a legal battle for the sake of it. Every day your property is occupied by a non-paying tenant, you are losing money. A $2,500 per month unit losing rent for 2 months during a contested UD costs you $5,000 in income, plus the legal fees. When you get to court, the judge isn't interested in your emotional distress or how much the tenant has wronged you. The judge is looking for strict adherence to the law. They will scrutinize your notice, your lease agreement, and your service methods. Any procedural misstep, even a minor one, can be fatal to your case. The burden of proof is on *you to show that you followed every single legal requirement. Judges often look for evidence of proper notice service, whether you accepted partial rent payments, which can waive your 3-day notice, and if you retaliated against the tenant. California's anti-retaliation statutes, Civil Code Section 1942.5, are robust. If a tenant can credibly claim you're evicting them because they complained about repairs, even if it's not true, it can severely complicate your case. Always have clear, documented evidence: photographs, dated communication logs, certified mail receipts, and proof of proper notice. Without meticulous records, your he said, she said argument won't stand up. A single judge's ruling can add weeks or months to your timeline. In a typical UD, if the judge finds an error in your notice, you could be ordered to reserve and restart the entire process, effectively adding another 30 to 45 days and hundreds more in legal fees. Assuming you win your unlawful detainer case, the court will issue a writ of possession. This writ authorizes the sheriff to remove the tenant. You then deliver the writ to the sheriff's department, who will schedule a lockout. The sheriff will post a 5-day notice to vacate on the property. After those 5 days, the sheriff will physically remove the tenant and restore possession to you. This is the final step, but it's not immediate. The sheriff's department has its own backlog and scheduling. From the moment you file the UD to the actual sheriff lockout, a typical uncontested eviction in California takes 45 to 60 days. If the tenant contests, files motions, or requests a jury trial, that timeline stretches to 90 days or even longer. For a $2,500 per month unit, a 90-day eviction means $7,500 in lost rent. On top of your legal fees, this doesn't include potential damages to the property, which are often significant after a contentious eviction. The sheriff is only there to remove the tenant. They are not there to ensure the property is clean or undamaged. You will likely face additional costs for cleaning, repairs, and rekeying. The best eviction is the one you never have to file. This begins and ends with rigorous tenant screening. Do you conduct thorough background checks, credit checks, and employment verifications? Do you contact previous landlords, not just the current one? Many landlords skip these steps or do them superficially, and that's a direct pipeline to future evictions. A tenant with a history of evictions or poor payment behavior in other states will likely repeat that pattern in California. For example, a comprehensive credit report costs you approximately $40. Skipping that check on a tenant who then doesn't pay for 3 months and requires an eviction will cost you easily $10,000 to $15,000. That's a 25,000% return on investment for spending $40. Beyond screening, early intervention is critical. If a tenant misses rent, communicate immediately and professionally. Don't let it slide. A 3-day notice to pay rent or quit should be served promptly. This isn't about being punitive. It's about establishing expectations and protecting your investment. If a tenant consistently pays late or provides partial payments, those are red flags. Address them. Document everything. Your paper trail is your shield in court. To recap, a California eviction is a costly, time-consuming nightmare. You're looking at 60 to 90 days from notice to lockout. Attorney fees can range from $3,000 for an uncontested case to $15,000 if it's heavily litigated. Remember, a cash for keys offer of $1,000 to $3,000 is often the cheaper, faster alternative to the legal process. Your best defense is a strong offense, rigorous tenant screening, and immediate, documented action at the first sign of trouble. Ignoring these truths guarantees you'll be on the losing side of California's tenant-friendly laws, powered by LeaseBase intelligence.